Hey, David, I'd like to talk to you a little bit about trademark litigation. People talk about trademark prosecution. How do you get a trademark? What's a good trademark? You've seen those things. Let's talk about when you have a dispute, when somebody's infringing your trademark, when there's potentially a likelihood of confusion, a competitor stealing your brand. Uh, what are the 5 things you need to consider when you look at this? Maybe even before you talk to a lawyer. Let's
Yeah.
start with, and I know there are 5 things, and between the two of us, we're brilliant trademark litigation attorneys. Just so happens we'll be able to come up with those 5 things. So what's number one?
Number one, I think in any lawsuit is just the strength of your claim. How strong is your case? Are you likely to win it? So for that, we'll want to look at the strength of your trademark rights. How distinctive is your trademark? And then, of course, the facts related to the infringement. How closely similar is the competing mark, et cetera. So we just want to look at the nature of the case first to see if it's a good one.
So the strength of your mark and the strength of their mark. I think the second thing, David, is what you alluded to here is the evidence of infringement. Do you have proof that the other side's actually using your brand in a commercial way, infringing your trademark? So is there a likelihood of confusion? In Ray DuPont, or depending on what jurisdiction you're in, maybe it's another case, but it's the same roughly 13 factors. Is there a reasonable likelihood of confusion as to the source or origin of goods or services in the relevant marketplace? Oh, we love that phrase. But what is the evidence of that?
Right.
David, what's the third thing you should think about before you file your trademark litigation case?
I think the third thing would be the potential damages that you could recover. You don't want to file a case. You don't want to spend thousands of dollars filing a case that you're only going to recover $500. So I want to look at the actual losses arising from the trademark infringement. How many sales did you lose? How many customers did that other company take from your company? In order to determine whether it's really a good case that's worth pursuing or maybe one that we would want to settle or deal with in another fashion. So definitely the damages.
So you don't want a Pyrrhic victory. I
Exactly.
mean, you don't want to spend tens of thousands of dollars or more pursuing a trademark infringement claim when there are no damages there. And I think trademark infringement damages are tougher than copyright because you don't have statutory damages. You don't have automatic statutory fee shifting. You don't get attorney's fees automatically. And courts sometimes are loath to award those. So I think that's a great point. And this brings me to the point of costs, right? So you have to also look at the costs of litigation. We talked about what the damages are, but as David alluded to, damages play into costs. You have to do a business analysis as to whether or not the trademark infringement's worth it. So rather than immediately filing a lawsuit, start with a cease and desist letter. And sometimes maybe you're even going to license that other party, or maybe you're going to enter into a coexistence agreement. You hate that they're infringing your brand, but maybe it's less expensive and it's so minor that there's another solution. So you have to look at the cost of litigation and whether or not actual litigation's worth it, viable, or even a reasonable alternative. David, what's the last and fifth and final thing you need to look at when it comes to trademark infringement cases?
Well, it kind of goes to what you were just saying about weighing all those options. You need a good attorney that's experienced in this area that can counsel you on these different pathways. It's not just sue or not sue. There's lots of different ways these cases can be resolved, and you need somebody with years of experience that's been through it to really walk you through all.
So that they know all of the different things. I mean, that's the problem, right? If you've only been doing it a few years, I mean, dare I say, it's been over 2 decades for me, but even 10 years might not have been enough for you to see all of the permutations and crazy stuff that can happen in a trademark case and ways to resolve it, creative ways to resolve a trademark infringement case that doesn't necessarily involve filing a federal lawsuit. It may, that may be your only solution, but let's start with something rational. Hey, thanks for joining me on our trademark information discussion. Thank you for joining us.